We're starting right now. Welcome everybody to our civil law work group. We have 3 bills on our agenda. We're going to start off with House Bill 722 because that is Lauren Nestor's bill. Do we have an amendment, Delegate Embry? Is there any amendments to it? No?
Chair.
What's that?
No, no, there are no amendments.
Okay. So I wanted to get an idea of whether anybody had any questions about this bill. We can let in Ms. Hoke if she's here, Ms. Egan if she's here, Ms. Malarkey, who else? Mr. O'Mealy, I think. Great. Okay.
Okay, everybody you said, Chair Cardin was there, except we're missing one person. So if
Right,
they're listening, please join the Zoom or let us know if you need the Zoom.
Right. Okay. So I really wanted to see if there's any, actually, I'm going to say this, that the chair wanted to make sure that everybody on the subcommittee understood this legislation and the impact it will have. So I asked the advocates and folks in opposition to join us so that they can answer any questions. I think that if there are any questions at all, that was really so that we can then sort of see. I'm waiting patiently. Is there anybody who has any questions? Delegate Conaway. Surprised you don't have any questions.
Just give us an overview again.
Why are you calling out Delegate Conway? Surprised I don't have it. Why?
All right.
Why?
I'm happy to do it myself, but I'll give Delegate Embry, since she's a sponsor, the opportunity to tell us what the bill does again.
Sure. So in Maryland, the doctrine of charitable immunity still exists. We're one of a few states, and that means that a charity is immune from tort liability generally. And this would say only for actions involving child sex abuse claims that charitable immunity is not available to nonprofits.
Yeah. I know that Professor Hoke did a yeoman's job in the actual hearing, but I'm going to give, why don't I give you guys 2 minutes, and I'll give Mr. O'Mealy a couple minutes also, just to remind us your positions on this. So I don't know whether it's Emily or Kathy, whoever wants to start.
Professor Hoke, you're up.
Kathy is fine. Thanks, Delegate Cardin. And members of the committee, I did testify at the hearing. The only point that I want to make now is to assuage your concerns about the retroactive application of this bill. Much like the Child Victims Act that you passed in 2023, there's a question: can we retroactively remove the statute of limitations, which is an affirmative defense? Here, charitable immunity as an affirmative defense. And I think there was some I don't mean this in the bad way, wishy-washiness in the Attorney General's letter on this, saying, not sure, right? It's clear it can be revoked prospectively. It's clear it can be revoked for claims that have accrued but not yet been filed. But if there are cases that are still pending and haven't come to final judgment, can we now remove the affirmative defense? And I think, again, the wiggle room that Sadie Brantley left in the AG's letter saying it may or may not be unconstitutional, I think we push toward that it would be constitutional to do that, based first on the Doe case that upheld the Child Victims Act, language in that making clear how limited something is, what vested rights are, and that a statute of limitations is not a vested right, and this affirmative defense functions quite similarly, because it doesn't have anything to do with whether a claim accrues. That's the language they use in Roe. I'm sorry, Doe. And just like there, you could choose not to raise the defense of statute of limitations. You could choose not to raise the charitable immunity defense. And so it is just like what you did in the Child Victims Act. Moreover, there is a case that I cited in my materials. It's State v. Smith from 2015, in which the Maryland Supreme Court makes clear that the elimination of an affirmative defense does not hinder, eliminate, or modify a substantive right, meaning a vested right, and thus a statute or rule that eliminates an affirmative defense can be applied retroactively. Unlike the case that Ms. Brantley cites in her letter, this case actually, where it was dicta language maybe, this case actually involved a claim that was filed. And then there was, a retroactive application of removing an affirmative defense. And so this holding is far more apt in this 2015 case. So I just want to assuage your concerns that there are no constitutional limitations to applying what's before you in 722 to cases that are currently pending. We can agree cases that have been concluded to final judgment are not going to be reopened, but pending cases, you can withdraw the charitable immunity defense. So there you go, Emily.
Thank you.
Oh, sorry. I don't know if you wanted to have questions now.
So,
Yeah.
well, I'm gonna let I would like to know if there's an intent, or there will be an intent, to try and challenge this in court, and whether you think there's constitutional issues. But let's wait and see. Ms. Malarkey, do you want to chime in at all? This is your shot.
So, I mean, just very briefly, obviously not to speak about the constitutionality, but just the public policy and the fundamental fairness that is involved with opening the courthouse doors to a group of people that have been shut out for a while, that have been a long time, not a while, a long time, who've been waiting to go to court, and then are having their cases dismissed because of this antiquated doctrine that Maryland is one of only a few states that continue to adhere to. The bill is narrowly tailored to deal with CVA cases only, not to abolish the doctrine entirely. The reason being that, as a matter of public policy, Maryland should not allow charities to hide when it comes to child sexual abuse. If there is ever a situation where a corporation, an entity, a business, even a charity should be held to account, it is when they allow children to be sexually abused. And we just have to decide as a state, is that something that we are going to allow to happen and allow these entities to hide behind this antiquated doctrine, or are we going to allow the survivors to come into court, which is what this body did 2 years ago? And as to your question, if you want an answer to your question, it's being litigated in court now because charitable immunity cases have been dismissed under the doctrine of charitable immunity, and they're going up on appeal as to whether the doctrine applies. Certainly judges have found that it does.
Okay.
So that's
Okay.
happening.
So thank you very much. I know I'm going to give Ms. Kraska and Mr. Amelia a chance to respond to in whatever capacity you do. I am interested in, and I spoke with actually Ms. Malarkey about this already. The idea that that you have an ongoing concern that has clearly over the last 30 years has rectified any problems they've had, and now they could potentially pay for the mistakes of a previous generation that could inhibit their ability to continue in the future. And whether that is a good public policy. I happen to, as somebody who does plaintiff's work at times, I always believe the victims need to be righted. There's no doubt about that. But the question that I have, and it seems like my connection may not be great. So I would be interested to see your response in terms of whether this policy is the right policy to go, and kind of knowing my disposition that I would tend to lean towards yes. I think that we should realize that victims need to be compensated. Okay. That being said,
Sure.
Mr. Amelia, you were on first. You go first, and then Jenny, if you want to follow up, you guys can have a few minutes.
Thank you very much. I'm going to respectfully disagree with Professor Hoch's opinion that the retroactive abrogation of charitable immunity would not be an unconstitutional divestment of a vested right. To the contrary, the Doe case decided by the Supreme Court in upholding the retroactive abrogation of the statute of limitations was very, very clear that had the statute at issue been a statute of repose, it would have been a vested right and could not constitutionally be abrogated. The same is true here with an immunity. The doctrine of charitable immunity, much like the doctrine of sovereign immunity, cannot be retroactively abrogated. And I would note that the Attorney General's office, and I haven't seen their letter on HB 722, but I would note that the Attorney General's office has filed an amicus brief with the Supreme Court in the Wicomico County versus Sturm case, in which they joined the Board of Education of Wicomico County in arguing that the Child Victims Act did not retroactively abrogate immunity, that the Child Victims Act was only focused on limitations and limitations only. And so with respect to charitable immunity, our non-public schools, our small churches, our volunteer fire departments, and other charitable organizations have relied upon this doctrine for well over a century. And we need to be able to rely on charitable immunity going forward. And of course, it only applies in cases where we have no insurance. It's not merely an affirmative defense, as Professor Hoke noted. It is a doctrine well-rooted not only in Maryland common law, but in its English predecessors that the Supreme Court relied upon in the early decisions. It's codified in the insurance article in Section 19103, which says that if you've got insurance, you cannot raise charitable immunity. So we're not talking about insured entities. We're talking about those entities that have no insurance. And importantly, as we noted in the letter that I submitted earlier, under the known risk doctrine, we cannot retroactively purchase insurance for an event that occurred previously. We can't buy fire insurance after the house burns down. And that's the dilemma that our small churches, our small non-public schools will find themselves in. We will literally have charitable institutions going out of business. And in response to what Ms. Malarkey said, I would respectfully submit that there is an equally important public policy in the state of Maryland to make sure that that does not occur. Our clients are faced with claims from decades ago when no one who's alive, except for the plaintiff, knew anything about the claim and for which we have no insurance. That's an untenable position, and that's exactly what charitable immunity was intended to protect against.
All right, thank you. Ms. Kraska, do you want to say, you have anything else to add, or?
No, I would agree with what Mr. O'Mealy has already stated. I think he did a nice job of stating our concerns on this. I would just point out, and I think he alluded to it briefly, is that the state is actively pursuing the dismissal of its claims that have arisen under the CVA for anything pre-1982, which was the formation of the Maryland Tort Claims Act. So it does seem just a bit hypocritical to me that the state would allow for that, but is trying to dismantle charitable immunity.
Thank you. I'm going to give Delegate Embry the last word. Is there anything else you want to say? We're not going to vote on this today because I don't think anybody knows where our committee is right now, and we want to let some of that digest. There's a lot. You gave us Professor Hoke and Mr. O'Mealy gave us a lot to digest, I will say. So thank you. Delegate Embry.
Thank you very much. And Chair, thank you for allowing us to talk through it and hearing from everyone. I really appreciate it. Just a few points. One is the reference was made to English common law. So yes, this was a doctrine that emerged in the 1800s in England. It was rejected in England in the same, within, I think, 20 years of being created because of the implications that it had for lack of accountability for entities in England. I think my memory is it didn't exist in England even at the point that it was being adopted in some of the colonies, and it's been rejected in this country roundly, especially as nonprofits have become so complex and do so many things, have so much money, and so it just, I think, is not applicable in today's nonprofit environment. And the final thing I will say is, I'm so sorry, is that we passed the Child Victims Act. And for that to be real, we spent a lot of time hearing these arguments. They're the same basic arguments that when you go back and eliminate a statute of limitations, it's harder to defend against cases. That is true. And there are organizations that exist that will struggle to defend in some cases. Those are the same arguments. And we decided that the rights of victims of child sex abuse were more important. So this, I think, is just a corollary to the work that we've already done. So thank you for letting me speak.
Anything to that?
You got it. Thank you very much, Delegate Embry. Appreciate that. And let me know when you're ready to go to the law school to start teaching your class.
I just want to go learn from Professor Hoke. That's right.
Okay. So we're going to hold this bill, but thank you. We really
Thank you.
appreciate everybody.
Yep.
And I think that Ms. Malarkey, you're going to stay on, right? Because you care about House Bill 526, right?
Sure do.
Okay.
As I depart, let me just offer, anyone can come sit on my class anytime. You just let me know. Take care, everyone.
Thank you, guys.
Thank you.
For those of you, I know that she's gone now, but I worked when she was a freshman teacher and I was a freshman delegate. Professor Hoke and I worked on my first bill and her first bill together. Is that funny? Okay, so we're going to talk about 526. We do have, there's some amendments that they want to talk about, but we have Delegate Kaufman's legislative staff on. I think that we have Mr. Enton. Hold on one second.
I'm here.
Chair Cardin, we have Jake, Nancy, Bob, and I don't know who is the iPhone NA. I'm not sure. Is that Nancy?
Nancy Egan.
It's if you can update your name, that would be great for us.
Nancy Egan. It's an answer you may have.
All right. And I think, and we have Jake Whitaker, right? Oh, we did that again. Okay, great. So Jason, do you want to describe the amendments? Well, do you want to describe the bill very quickly and then describe the amendments?
Yes, sir. And Emily Malarkey from MAJ, she's going to be joining us as well.
Right. She's here and
I'm
she
here.
can certainly chime in if you need her help. That's no problem.
All right. So this bill is pertaining to settlements when it comes to settlement agreements and the way payments are being made after a settlement. All right. So when there's a judgment, then interest starts being accrued after payments, when payments aren't made after a certain time. But that's not the case when it comes to settlement agreements. Right. So the issue is that during some settlement agreements with insurance agencies, the payments are prolonged. Right. So that's the gist of the bill. And we did make amendments to address concerns that were brought up during the hearing. Right. So one concern was about the Medicare reimbursements. Right. So now we added that. So before a payment is made to Medicare, then the amendment would allow payment into an escrow account to qualify for the payment, so that the hospital, the insurance agents can make payments to Medicare. And Emily, correct me if I'm wrong on that part.
No, you're correct. The plaintiff can make payments to Medicare out of the settlement funds, which is most of the time the way that it happens.
And that would reduce liability on who is concerned, for people that are concerned that they would be on the hook. Is that?
Right, so the plaintiff is always on the hook for paying back liens of any kind out of a settlement. That's the plaintiff's responsibility. And when cases are settled, it's written into every settlement agreement that I've ever seen that the plaintiff will, and if the plaintiff fails to do so and someone tries to come after the defendant, the plaintiff will indemnify the defendant because it's not their responsibility. On occasion, in our cases, complex cases, we are now increasingly seeing defendants want to take on that responsibility themselves, in particular as it relates to Medicare, because under the Medicare framework, the defendant is equally responsible for paying. But under this particular bill, the parties can work out who's going to make the payment. And if it is agreed that the defendant will make the payment to Medicare, there's no reason the plaintiff's portion of the settlement needs to be held back for the entire time. So that part would be.
I see, Jake, I see that you have your hand up, so we'll get in a second. My question is there still liability on the defendant if the defendant's required to pay, or I guess jointly liable to Medicare? Can we understand why they would be concerned about making payments when there may be an outstanding debt due?
So that's what I was trying to explain, perhaps inartfully, in my prior answer. Under the Medicare statute, both parties are responsible for paying the lien. However, in the vast majority of cases, the way that's done is the money is paid to the plaintiff pays the lien, and the defendant is indemnified if the plaintiff fails to do so. But what this bill allows, which is also a way it is done, is the defendant, if it's agreed and negotiated that way, can hold back the portion of the Medicare lien that they would be responsible for and still have to pay timely to the plaintiff. So the plaintiff is not waiting around if there's a delay. Does that make sense?
Yep. Jake, is this about the amendment?
Yeah, thank you, Mr. Chair. Our concern is about the Medicare liens. So we would still be subject to federal laws in regards to the Medicare liens. So our biggest concern that is if we had to pay the plaintiff the money that was owed to Medicare in the liens, we could potentially have to pay that money 3 different times. So for example, oftentimes Medicare will come after the defendant or the hospital when the lien's owed. So if we paid it to the plaintiff, we would also owe it to Medicare. But Medicare also has a statute where they can pursue double damages. So we'd potentially be on the hook for 3 times the money. So while I appreciate the sponsor being flexible with the amendment, we're still bound by federal law. And frankly, the practice of Medicare is to go after the hospitals.
Right.
So the challenge.
That was my question to Ms. Malarkey, maybe. I don't know if Ms. Newman, I'm assuming, Jason, that you want to defer to Ms. Malarkey. When you say that you indemnify the defendant, is there, whether it's case law or is there something in the contract that specifies that they're not permitted to go after? Because I can see them going after the defendant because they're the easy ones to target.
So I take issue with the statement that most of the time Medicare goes after the hospitals or the defendants. That is, I don't believe to be true. There are people experts on this issue we can bring in if that is necessary, but that has not been my experience. It is absolutely true that in a contract, a release that memorializes the terms of the settlement, the parties do have to always discuss and agree on how any lien is to be paid. If the plaintiff is the one who bears the responsibility for paying it and they do not, the language in the contract requires the plaintiff to indemnify the defendant for any harm the defendant suffers and actually step into their shoes and defend them in court. So the notion that a hospital could be liable 3 times if the plaintiff does not pay a lien is just not accurate. If the plaintiff doesn't pay a lien and there's language in the contract that the defendant is indemnified, then the plaintiff is the one who's going to be on the hook for not paying lien and indemnifying the defendant and paying any damages that result from that. And lawyers who handle these cases have ethical obligations to ensure that liens are paid. We take that very seriously, and no one wants to lose their law license. So liens are paid. And if it's negotiated in the deal that the defendant gets to pay the lien directly themselves, that shouldn't be a reason to hold up the rest of the settlement payment for sometimes months on end.
So because it's another minute to respond. I just want to know
Can't hear you. Delegate, can't hear you. Now I can.
Mr. Chair, you're on mute.
I'm sorry. I was sitting there on mute talking to you all, you guys, for like the last minute. I want you to respond if you want to, Mr. Whitaker, but my question is, do you prefer this bill with this amendment or without this amendment more? Just so we understand whether, I understand that you're opposed to the legislation, but does the amendment do any good for you guys?
Unfortunately, Mr. Chair, I just don't think the amendment or the bill kind of achieves or addresses the concerns that our members raised. When I spoke to our general counsels, they say Medicare is paying the hospitals to provide these services that are the basis for the liens. So it's only natural that Medicare would go after the hospitals to recoup those liens. I think additionally, there's literally a federal statute that says they can go after us for double damages, and I'd be happy to share that after this hearing as well. So I just want to reiterate that it doesn't address those challenges. And hospitals are just concerned that we'd be on the hook for triple damages when we already have a system that works. Thanks.
Okay. Got it. Mr. Anton, I see that you're there. Do you have anything you wanted to say? Wait, you're on mute, Mr. Anton.
On behalf of the American Property Casualty Insurers Association, we were, you may recall, very much opposed to this legislation. We've never seen this bill before. We've never had anybody reach out to us or our carriers with complaints about this. I didn't see Holly's email until later this morning, and I don't have the code with me. But I would tell you that unequivocally and clearly, under the Maryland insurance article, under what's called the Unfair Claims Settlement Practice Act, if we are delaying payment for without some reasonable basis, then we would have liability for heavy penalties under the Unfair Claims Settlement Practice Act. The amendments really don't do a thing. They increase the 10 days to 15 days. So now it's 15 days instead of 5 days to 20, whatever it is, 20 days or whatever it is to 30 days. The problem is you can't you pick these arbitrary dates, and who knows what happens in the facts, but automatically, regardless of whether a suit's been filed or hasn't been filed, automatically now you're accruing interest at the rate of 10% per annum. We're very much opposed to it. I'm happy to provide to the subcommittee and the full committee the provisions of the insurance article. But I've been representing the property casualty insurance industry for probably 25 years. It's the first time I've ever heard of a complaint on this issue. I don't think it's anything that happens with any degree of frequency at all. We'd ask you to give the bill an unfavorable report. The amendments don't make a bad bill better.
Okay, that was the last question that I had for you. Thank you. Mr. Nunez, can you just indicate to us whether originally MACO came out opposed and MML, I think, came out opposed?
They did.
Do you know if they have changed? This amendment solves their problems? Is that true or not true?
It's true. So amendment number 4, I sent the email yesterday. Amendment number 4 is removing local government. And so our intention was never to incorporate local or any municipality in the bill. And so MML, MACO, and the city of Baltimore, they all changed their position. And so on page 2, line 7, that's when we included the language that says the individual paying. Let me see. So in any action brought against the county or municipal government, so they're not liable for it. So this bill is not including local government. And
local governments can't pay on time. They don't have to pay on time, but everybody else does.
Well, they're not, well, they have a different process. Their insurance department, or the way they handle insurance claims, it's a little bit different than the way the insurance agencies.
The Child Victims Act, we didn't say that the state was absolved when all the private entities were. Why should the municipalities and the counties be absolved from making their payments on time? I'm just curious. Just wondering.
And I could speak with them about it and get back to you if you like.
Yeah. All right. Okay. I'm going to give Miss Malarkey and then Mr. Enton one more bite at the apple, and then we're going to be done because I've already held everybody much longer than I expected to.
And I will be extremely brief. It is a problem. If it wasn't a problem, we wouldn't have brought the bill. The insurance complaint that Mr. Enton mentioned, that may help the state get money from fines and penalties, but it doesn't help the plaintiff who needs the money for basic living, which is why we brought the bill. And the other thing I wanted to point out is that there are 5 other states that have statutes like this: Florida, Illinois, New York, Pennsylvania, and Rhode Island. This one is modeled off of Illinois. All of those states obviously have to follow federal Medicare law. If they can do it, we can do it. And there's no reason why that should be a holdup to getting this through the finish line.
Okay. Is there any last comment, Mr. Enton or Mr. Whitaker? I feel like I'm in court when I always give the plaintiff the last word here. So we're going to give the defendant the last word.
I just wanted to add that if they want to amend the insurance companies out of the bill, we probably would take that into consideration in our position as well. I mean, obviously, once again, this bill will have a problematic effect on how these cases are handled. Thank you.
Thank you. So I would take a motion on the, it seems like the amendment is not that offensive, but I think we're holding this bill because clearly we still have some disagreements. So I think we're going to hold the bill. And well, let me ask, is there somebody who wants to make a motion on the amendment before we hold the bill? Or are we going to just hold it? Okay. So there's nobody that has a dire need. So, Mr. Nunez, you can tell your boss that we appreciated all the information we got today, and we're going to continue to take a look at this. Okay.
Yes, sir. Thank you so much, Mr. Chair.
Thank you. I was going to try and bring up 466 briefly. We're not ready to vote on that either, but I think that we will probably take that up at another time. Is that okay, Delegate Embry? I don't want to strain your brain waves too much. Okay.
Very much so. Yes, thank you.
Thank
Give
you
us
all
time
very
to go
much.
to the committee. Yep.
I very much appreciate everybody coming on. These are important discussions that we need to have, and I will be I'll be meeting with committee members to kind of see if there's anybody who has any particular issues on these bills and see what we can work on. Okay. Thank you all very much. Any questions for the order before we end? That's for delegates, not for non-delegates there. Any other questions? Great. Thank you all very much.